Hello, everyone, and welcome to One Civil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal educational content, and today will be the day I earn that subscription. For today's story, we have some more things in the ongoing Take Care of My trial, which the trial phase is still ongoing as we have not yet reached a judgment. But we have some additional orders and findings from the court. Plus, we have copies of some of the documentation relating to J. Hatch's many medical problems over various time periods, which we will skim through because it's quite lengthy, but we'll try to discuss at least some of the highlights of it. So let's go ahead and get started with what the judge ruled on today. So first, of course, we have an order denying the motion for a new trial based on juror number 1. No surprise to anyone there. The judge writing before the court, following a hearing and jury interview, which should never been granted and was a whole pile of stupid, is defendant Johns Hopkins' motion for a jury interview, motion to open discovery, and emergency motion to preserve. J. Hatch supplemented these motions 3 times in writing, including by the secret S's. The S's are sharp, therefore Nazis. This was a real thing that a real attorney really wrote. Unbelievable. Plaintiff responded to the opposition. On December the 15th, the court granted a non-evidentiary hearing on the motion. On January 3rd, the court conducted the interview. Because J. Hatch failed to demonstrate any jurist misconduct, the court denies the motion, as well they should. They shouldn't have had the hearing. I don't know why they had the hearing. It seemed bizarre to me. But, I'm not the judge, so what can you do? On September the 14th of 2023, the juror reported for jury service, as one does, and received the oath as a prospective juror, as one does. After both individual questioning and group questioning, the juror was seated on the jury. On September 19th, the clerk administered the oath. The same day, he was seated with the consent of the parties. On November the 9th, following delivery of the verdict in the punitive damages phase, the court discharged the jury with consent of the parties. J. Hatch raises in his motions and supplements many issues concerning juror number 1 that J. Hatch claimed demonstrated misconduct by the juror during the trial, which they really didn't. They spoke to a lot about his wife and Jules, which I'm not sure how those people are juror number 1, but okay. Also, not sure how even Jules or his wife did anything improper, but okay. These allegations include juror number 1 alleged failure to abide by court instructions. On December the 15th, the court conducted a hearing. By order dated December 20th, the court allowed limited juror interview on 4 different topics. The court determined that other requested bases for an interview were either untimely, meritless, or both. I would have said stupid and ridiculous and absurd and frivolous and sanctionable and disciplinarial bull, but we'll go with untimely and meritless. The court set that jury interview for Wednesday, January 3rd. On Friday, December 29th, after 3 p.m., J. Hatch filed its first motion for the stupid. For reconsideration, J. Hatch doubled down on his claims and affirmatively and prospectively alleged without proof that juror 1 would lie during the jury interview. J. Hatch confirmed in this reconsideration that the 3 supplements were a result in part of investigations by Joe Hatch's internet communities, namely to say Reddit. Reddit is actually manifesting change in the world. I don't know how to feel about this. Actually, I do know how to feel about it. It's bad. Reddit should not be allowed anywhere near a court process ever. Next, they'll be quoting 8chan or 4chan or something. On Tuesday, January the 4th, the first business day after J. Hatch filed his motion, the court entered a 14-page denial. The court declined to expand the scope of the interview that was to occur and further explained why the subjects not included were untimely or meritless or both. Or, again, if it's me writing, stupid, frivolous, sanctionable, disciplinary worthy, and affront to all that's good and right. But sure, meritless. On January 3rd, the undersigned conducted the jury interview of Juror 1 in open court in the presence of the party, media, and public spectators. Juror 1 appeared with his attorney. The court questioned Juror number 1 as to each of the bases identified in the order. The court allowed the parties outside the presence of the juror to suggest additional questions. The court then asked some follow-up questions and details the findings below. Now, I'll note this, of course, as well, that These are findings of fact by the finder of fact. We've discussed this before, right? Jurors are the finders of fact with respect to the case. They're finders of fact with respect to, did Johns Hopkins do it bad? That's the question they're there to answer, right? So that's what juries are for. Anything outside of that is for the court as the finder of fact. So did the juror do it bad is not have anything to do on its own terms with whether J. Hatch did it bad or not. We were discussing this also as it relates to the Alex Murdaugh case today, where the retired Chief Justice of the South Carolina Supreme Court was finding facts and scheduling a hearing for further findings of facts, which they can do because whether or not the clerk corrupted the jury doesn't have anything to do, strictly speaking, with whether or not Murdaugh murdered anybody or not. Right? It is tangential to the actual issue we're trying to solve. So the court, when they say these are findings of fact, just as surely as much as a jury came up with them. So the same sort of standard would apply in a review sense. So, basically good luck, because now the court is the finder of fact, and that's fine. No problem. So the court now gives your findings of fact. These are facts now. As to the 2002 case, J. Hatch contended that the 2002 circuit case from the 17th Judicial Circuit revealed a reference to abuse and DCF. This was concerning to J. Hatch because they were so desperate for anything that they were grasping at the last bit of straw, but ostensibly because the subject matter of the current lawsuit include discussion of DCF's actions in sheltering Maya because of a claim of medical abuse. J. Hatch points to juror number 1's no response to supplemental questionnaire when asked if juror 1 had any close friends or family members with a child sheltered in protective custody, or if juror 1 had any strong opinions concerning DCF's ability to take children into protective custody. Incidentally, I have some concerns about this, but that's neither here nor there. The court received into evidence the 2002 docket during the jury interview relating to this stuff dealing with, the juror's prior life from 20 years ago. The public docket in that case reveals the case was an interpersonal violence petition filed by juror number 1's then wife against juror number 1. Juror number 1's wife then failed to appear at the return hearing, and the petition was dismissed because she didn't show up. So that was sort of the end of that hearing. Yeah. During the court's questioning of juror 1, juror number 1 credibly, and this is a finding of fact, confirmed that there was no involvement by DCF during the 2002 case, and that juror 1's then minor child was not taken into protective custody by DCF or otherwise sheltered. Juror 1 has also credibly explained that when he filled out the supplemental juror questionnaire in the current case on September 14, 2023, he has no opinion whatsoever of DCF or the government's ability to shelter. There's no evidence that any of juror 1's answers on the supplemental questionnaire regarding DCF were incorrect. The 2002 Broward case from over 2 decades ago does not demonstrate any juror misconduct. Fantastic. No problem. Works for me. As to whether or not juror number 1 knew attorney Deborah Salisbury, the supplemental juror questionnaire included, among other questions, 97 names of potential witnesses. The supplemental questionnaire instructed the potential juror to answer yes or no for each of the 97 listed potential witnesses, whether the juror knew or thought the juror knew of the potential witness. J. Hatch contends that juror number 1 improperly said no to question 74 on the supplemental juror questionnaire regarding knowledge or potential knowledge of the potential witness, Deborah Salisbury. Ms. Salisbury represented Jack Kowalski for some portion of the dependency court proceeding. Ms. Salisbury never testified in the trial. As presented in the written motion, J. Hatch reached his conclusion. Speculation, wishes, and dreams more than a conclusion. I would, again, conclusion sort of implies a good faith logical process as opposed to dreams we had from Reddit. So I don't know that I would call it a conclusion so much as the schizophrenic rantings of a madman. But, conclusion, I guess. The conclusion of the alleged juror misconduct based on an unidentified 2007 domestic relationship proceeding filed in Sarasota County involving juror number 1's current wife. The written motion did not provide more detail because J. Hatch either didn't look or did look and they were being disingenuous. During oral motion on the argument, J. Hatch affirmatively represented to the court that Deborah Salisbury was juror number one's wife's attorney for her divorce proceeding, the same attorney that represented Mr. Kowalski. Miss Salisbury disagrees with that. And Miss Salisbury would very much like you to keep her name out of your mouth, if you don't mind. That declaration by Deborah Salisbury was a very well-earned, professional FU. And I was definitely there for it when we read it. Prior to the jury interview, Deborah Salisbury filed an affidavit in which she asserted J. Hatch's allegations were false. Ms. Salisbury stated she never represented juror number one's wife in any capacity whatsoever. She advised that the court docket from juror number one's current wife's 2005 divorce proceedings, which incidentally, of course, juror number one wasn't involved with because she wasn't his wife at the time, from her former spouse demonstrates on its face that the docket for both parties in the case were self-represented. In other words, neither party had an attorney. And it is objective fact easily discernible from the docket. Ms. Salisbury attached the 2005 docket to her affidavit, and the court concurs with Ms. Salisbury's observation concerning this objective fact. Again, this is a little bit too passive for my taste. This is a little bit too passive and neutral for my taste. I'd be beating everyone to death on the page. But sure, that's one way to characterize it. I think a little righteous indignation is not necessarily inappropriate or unprofessional, at least in my humble opinion. So when you've earned that righteous indignation, I don't think you necessarily need to write it in this, shall we say, clinical of a method to still be professional, but that's merely my view of the thing. Ms. Salisbury further stated in 2007 she was appointed by a family law judge to represent an individual in the domestic relation proceeding, which almost certainly is a child, because who else could it possibly be? Right? I mean, who else could possibly have an interest in a divorce? Right? Who are possibly interested parties in a divorce? Well, the wife is an interested party in the divorce. The husband's an interested party in the divorce. Who else other than the husband or wife could possibly be an interested party in a divorce? There's not a lot of other possibilities left. It's a child. I mean, we can't say it, but we all know it is. So the judge appoints an attorney for the child because child. Great. Ms. Salisbury discussed in her affidavit that she attended a brief hearing in 2007 where the juror one's current wife may have been present. Ms. Salisbury's role in the proceeding was not to represent juror one's current wife. Instead, her representation was, strictly speaking, adverse to the current wife because, well, you know, the child may want things that are different from the wife or husband or both. So her role is necessarily adversary because they might want different things. What a strange concept. $5 from Hippo Lover. Thank you for the hippos. Hippos make me happy. I like hippos. In the current case, J. Hatch has done nothing to clarify its position with respect to Attorney Salisbury, retract any representation, or dispute the affidavit because there's nothing to dispute. J. Hatch should be ashamed, but I'm not sure they're capable of shame. I'm not sure they know it. If I become a judge, there will be whacking stick. I may get myself whacked by the Court of Appeals, but there will be a whacking stick. We'll find out. During the juror interview, juror one testified that he and his current wife married in 2016. Well, strictly speaking, yeah, I guess he did finally say he guessed. But fortunately, he guessed correct. He also testified credibly that on September 14th, 2023, when he filled out a supplemental juror questionnaire, he did not know the Attorney General Salisbury. There's no evidence juror one even knew his current wife in 2007, and I don't believe they did, as a matter of reality. J. Hatch's claim knew that juror number one knew Ms. Salisbury is meritless. There's no evidence of juror's misconduct on the issue. Again, meritless is not exactly my first word choice, but, you know, sure, meritless. We'll go with that. Whether juror number one spoke with his wife about the case during the trial. Did you know they might live together, guys? Did you know that? Did you know that Juror 1 and his wife might live together? Did you know that? J. Hatch attached to its motion several internet postings made during the pendency of a trial about the trial that J. Hatch attributed to Juror 1's wife, who may or may not be a distinct entity or thing from Juror number 1. We're not sure, given J. Hatch's motion. I mean, I was under the vague impression that women were independent people, but maybe not. Maybe they're, fully subsumed by their husbands, and we're going back, I don't even know how far in law at this point. A while. J. Hatch is attached a screen grab from the broadcast of October 30th, 2023, trial day, depicting Juror number 1's wife sitting next to an individual J. Hatch contended was pro-plaintiff and who appeared on various internet shows that were reporting on the trial. While J. Hatch contends that the contents of Juror number 1's wife's posting suggested there were communications between herself and Juror 1 concerning the trial, which they absolutely did not, the court disagreed that those postings led to the conclusion because it was a dumb conclusion and J. Hatch should be ashamed. For instance, Juror number 1's wife posted prior to the testimony at Detective Graham that a law enforcement juror would have questions for Detective Graham, which, probably. I mean, if you were just guessing, yeah. Also, she might understand something about how her husband thinks. I mean, I would think possibly, assuming for the sake of argument that she does in fact live with her husband, although we don't know, that she might have opportunity to observe him and his thought process and might have some clues as to how he thinks and goes about things. I don't know. Just some rank speculation. I think husbands and wives, generally speaking, get to know each other reasonably well. I mean, yeah. As the court previously explained in open court, anyone following the case knew Juror number 1 was retired law enforcement, and Juror number 1 was asking questions of most of the witnesses. Juror number 1's habit of asking a witness multiple questions was predictable. Perhaps not as certain as death and taxes, but nearly as certain, such as a traffic backup on the I-4 near the Disney Champagne Gates area. Cute. I like it. A little local flair. I like it. Internet postings suggesting Juror number 1 would have questions for witnesses, including a law enforcement witness, did not fairly or remotely suggest discussion between Juror 1 and his spouse. There were other posts, too, that J. Hatch contends shows communication, but in context of the case have innocent explanations and do not suggest insider knowledge or improper communication. Nothing about the questions suggested to the court that Juror number 1 was speaking to anyone, including a spouse, about the case. Regardless of the court's construction of the posts, though, the court allowed the juror interview on this topic, which I don't know why, but they did, but okay. The court directly questioned Juror number 1 whether he had any conversations with anyone, specifically including his wife, about any matter associated with the trial. Juror number 1 credibly and forcefully testified he did not have any such conversations with anyone, including his wife. He also credibly suggested any suggestion that the communication improperly with his wife, even non-verbally. Once again, just as a friendly reminder to our anti-Maya Reddit friends out there, these are findings of fact now. The judge is laying out facts, and the Court of Appeals is not going to touch this with a 10-foot pole. So, just in case you care. Yeah. Yeah. Basically, is it possible for any reasonable judge to come to these conclusions? Yeah. So, the Court of Appeals is not going to care. I'm not sure why they have Juror number 1, wife, and Jules as a bug up their ass, but they seem to for some reason, which I don't completely understand, but okay. There's no basis for the court to conclude either by content of the questions themselves or following the interview that Juror 1 had any proper communications, including his wife. This claim does not show juror misconduct. Whether Juror number 1 obtained information about the case, J. Hatch also contends that Juror number 1 violated the court's repeated instructions not to investigate or receive information about the case outside of court. Specifically, J. Hatch contended that on October 9, 2023, Juror number 1 used the term creature comforts which must have come from the website because no one else uses that term ever, right? In a question to the witness, J. Hatch identified a screenshot purportedly from Dr. Anthony Kirkpatrick's website that contains the apparently unique, truly unique, one-of-a-kind phrase, creature comforts. It's the only time anyone would use that particular phrase. Based on this happenstance / the stupid, J. Hatch leaked to the conclusion that juror number 1 is performing investigation outside the court. Plaintiffs in the response observed that on September 28, 2023, a witness in open court before the juror used the same creature comfort phrase. Also, it's a pretty common phrase. Also, it's a pile of stupid. Given juror number 1's habit of taking copious notes and referring to them when formulating questions, the plaintiff posited that J. Hatch's theory is unsupported. Despite the innocuous of the phrase and its common usage in our lexicon, whoa, other people use it? The court permitted a juror interview on this topic for reasons that, again, pass my understanding, but they sure did. Again, the court questioned juror number 1 on whether he conducted any investigation outside the court. The court specifically asked juror number 1 if he either used computer to review Dr. Kirkpatrick's website, or whether he read the website even if someone else, such as his wife, left it visibly for him to review. Juror number 1 again credibly testified he did not investigate, and further credibly testified he did not seek out or review Dr. Kirkpatrick's website. There's no basis for the court to conclude juror number 1 performed any out-of-court investigation. Having reviewed the motion supplements, listened to oral arguments, and conducted an interview, we find this is all a bunch of bullshit and go away. Great. That takes care of that one. All right. Let's see what's next. We've got an order on post-trial motions. Well, let's read this one. Yeah. How y'all doing? You having fun out there? I'm having fun. I had a good day at the gym today, incidentally. I went to the gym yesterday and today, so I'm feeling buff. I'm also experimenting with a powdered green juice. So I'm doing this Amazing Greens, 2 scoops of green powder with some Crystal Light to help make the flavor work, and it's actually pretty good. So I'm looking for a good green powder, and Amazing Greens seems to be working out well so far. So if anyone has any recommendations for a better green powder, let me know. But this one works pretty well with Crystal Light, I have to say. All right. Right now I'm using the peach tea flavor, and it tastes pretty good. With respect to the order on the, thank you, Marvin CZ, for the 200 CZK. We do appreciate it. All right, let's read this. Order on post-trial motions. Pain more intense than childbirth. Pain more intense than a kidney stone. Pain more intense than amputating one's limb. The worst pain imaginable, the degree and intensity of which both of us cannot comprehend. Pain so intolerable the condition is nicknamed a suicide disease. This was but a small portion of the evidence presented to the juror concerning the pain associated with a condition called CRPS. Maya Kowalski contended at trial that she had CRPS and had CRPS when presented to Johns Hopkins. Johns Hopkins disagreed she has CRPS. Well, strictly speaking, I'm not sure they ever took a position on it, but whatever. And the jury was presented with evidence that healthcare providers at J. Hatch believed she was faking it. And there was evidence that J. Hatch treated her, or more precisely declined to treat her, accordingly. The jury learned of this failure to treat CRPS will increase the number of, severity of, and duration of future CRPS flare-up episodes Maya will experience throughout her life. In other words, there was evidence that J. Hatch, by its conscious indifference, sends Maya to even a more extreme, debilitating pain that she would have had to endure through her life than she otherwise would have had they correctly treated her. Fair. You can't sanction Johns Hopkins for the underlying CRPS, but you can sanction them for anything they did to aggravate it. So trying to figure out the differential is tricky, but there can be no question the jury credited Maya Kowalski's version of the evidence. Yeah. And the jury rejected J. Hatch's claim it provided Maya with exceptional, compassionate, and heroic care. The jury rejected J. Hatch's belief that it was Maya's savior. Somewhat, yes. The jury found that J. Hatch on at least 3 separate occasions falsely imprisoned Maya Kowalski, and J. Hatch on at least 2 separate occasions battered Maya. J. Hatch's management knew about this intentional misconduct and directed it, condoned it, and ratified it. J. Hatch was also intentionally inflicting emotional distress upon Maya. Yet J. Hatch continues with its quest to immunize his conduct, even though that conduct does not remotely result from its calls to DCF abuse hotline or its participation in the dependency court proceeding. Truth. Truth. They went outside those boundaries. Truth. The jury also was presented with evidence concerning J. Hatch's egregious treatment of Maya Kowalski's mother, Beata. Based on the treatment, the jury found that J. Hatch intentionally inflicted emotional distress upon Beata that resulted in her death by suicide. And as I've pointed out, and will continue to point out, this is by far and away the most legally problematic going forward. And, you know, I don't really see how this doesn't wind up at the Florida Supreme Court someday, because it's kind of a big deal. So I don't know what's going to happen to that in the end, but it should be interesting to watch. So that continues to be J. Hatch's best argument. And if they can win, they get about half the damages to disappear, which is good for them, I guess. So we'll see. On a personal level, as I've discussed before, for reasons we've discussed at length, I don't know if it's strictly speaking a personal issue or a personal belief. Maybe it's a professional belief. I'm not sure which it is. But as a personal/professional belief, I'm not sure that this cause of action against J. Hatch is wise as a matter of law. It, at least to my mind, opens up too many unhappy possibilities. And I'm, of course, naturally conservative, so I get a little bit worried when I'm like, okay, you've just done something and I'm not sure what happens next. So I have deep reservations about this cause of action, but the Florida Supreme Court's probably going to have to solve that someday. That we'll figure that out later. Post-verdict, J. Hatch timely filed an omnibus 144-page motion entitled the renewed motion for a directed verdict, motion for new trial, and motion for remitterer, which is just a reduction, to remit. That motion includes a 6-page table of contents and some other stuff. Plan filed an 89-page response. Maxim Bacon says it's legally almost impossible to prove. Well, I'm not sure it's legally valid. So you first have to figure out what you're trying to prove. I'm not sure it's a valid legal cause of action. So I'm not sure it's a valid legal cause of action. So yeah, you can't prove something that doesn't exist. An overarching theme of J. Hatch's motion is it did nothing wrong, and its actions were rather ordinary. The jury rejected this view of the evidence, and its motion J. Hatch either ignores or minimizes ample evidence of misconduct. Having sat through the entire trial, the court rhetorically wonders what J. Hatch's definition would be of an extraordinary action. Cute. That's cute. Nice. Just because the court remitted a few jury awards, apparently there's been a slight reduction, it does not follow that the entirety of the jury's verdicts were improper or a product of passion. They were not. The reader should not lose focus that the case was qualitatively different than most other cases. In terms of novel issues, the juxtaposition of a dependency court proceeding, immunities, the vast number of disputed evidence, the parties' conduct, damages sought, disagreements between counsel, length of the verdict form, and consumption of judicial resources, just to name a few. There are more than 4,100 docket entries, which is a lot. That should not be. That should not be, man. 4,100 docket entries? 4,100 docket entries shouldn't happen in anything like a complex class action. This is not that, man. 4,100 docket entries? The jury invested 2 months' time listening to complex and often very contradictory evidence. They were attentive and engaged, and they asked questions, many questions. They deliberated for 2.5 days in the first phase of the trial. Despite the picture painted by J. Hatch, the jury did not go off the rails. For the most part, the court rejects without comment J. Hatch's contention, for reasons explained during trials, those cited by plaintiff's response. The court writes only an additional few. For the reader's ease, when the court writes on an issue, the court has attempted to identify and retain J. Hatch's numbering and lettering, but the court did not always proceed in the same order as J. Hatch's motion. For the readers should not expect sequential. So we're going to adopt the same lettering and numbering, but not go in the same order. Fine. As to issue 2, issues affecting all claims. J. Hatch in its pages raised 5 separate issues that J. Hatch contends affected the trial. The court disagrees. For the most part, the court rejects J. Hatch's contention for the reasons explained during the trial as well as those cited by plaintiff in their response. The court writes on only 2 of the contentions. The scope of the immunity. We've already been to the Court of Appeals and back on this, haven't we? J. Hatch contends the court should have extended the immunity afforded by law to cover virtually all of its actions while Ma remained at J. Hatch during the court proceeding. This includes J. Hatch's decision without input from DCF or the dependency court, which is kind of the problem, to place Ma in a video surveillance room to confirm whether actions are consistent with CRPS or instead consistent with psychological problems that may have been caused or enhanced by the mother's behavior. Which, as I pointed out before, like even if you assume that's true, if that's the purpose for it, why aren't the results in the medical records? Right? If we put her in the room for the purpose of determining whether she's malingering or has conversion disorder, why is there no record in her medical records about the observations and stuff, like you would expect? Same with documenting her skin. Is it as if you assume that they removed her clothes to document her skin condition, then why is there no records in her medical file about her skin condition? No observations, no notes, no prognosis, no diagnosis, not even a no conditions detected note, nothing. Yeah. J. Hatch has no explanation why, if these actions were taken for medical reasons, Maya's medical records are not littered with reports. That's almost like exactly what I just said just now. Wow. It's nice when the court gets to the same place I do. It makes me feel smarter inside. Well, court, you and I came to the same conclusion. What an amazing thing, right? Why, if they're taken for medical, why aren't they in the medical record? That's a really good question, court. I almost said that just 2 sentences ago. So why are there not reports, observations, photographs, and other notes? And the results there too. Yeah, certainly the jury was presented with evidence and lack of medical records, explaining the necessity to place a commode just outside of reach, and then intentionally delaying incoming help to use, causing her to defecate on herself. If stripping a child and taking photographs was done for medical reasons, where's the concurrent medical record evidence? That's a really good question, court. That's a really good question. Where are the reports? Where's the documentation? Where's the observations? Where are the notes? That's a really good question. Yeah, I don't know. Well before the trial, the court addressed several summary judgment motions based on the scope of the immunity. The court will not restate its prior analysis other than note the legislature in the statute commends good faith for immunity exists. The court previously notes its concern about the binding precedent of relevant law that appears to write out the legislature's good faith command to secure immunity. But the court, of course, is bound by those decisions. The court followed them and eliminated some of the causes of action even without a showing of good faith. So fair enough, the court applies the relevant law as the courts of appeal have deemed it so far. In addition to the good faith requirement, immunity is further qualified by the what might otherwise result clause. Committing intentional torts, performing medical malpractice, and engaging in fraudulent billing do not otherwise result from the participation. Preach. There was evidence from which a jury could find J. Hatch intentionally engaged in these torts and committed malpractice. Further preach. Yeah. The court knew where to draw the line on allowing or disallowing evidence in effectuating the immunity, would scrutinize by the losing party or parties. As the court repeatedly told the parties, the trial on remaining causes was not to be a litigation in the first instance of the issues that would have been tried in the dependency court had Beata not died of suicide, but both sides constantly attempted to do so. On the one hand, J. Hatch objected to and heavily criticized any effort plaintiff made to introduce matters that occurred in dependency court. On the other hand, J. Hatch repeatedly attempted to litigate the court claim from the dependency court that Beata committed medical malpractice or medical child abuse on Maya, and that Beata suffered from Munchausen syndrome by proxy. The court, although I'd already ruled J. Hatch immune from all claims that would otherwise result from the agency reporting the suspected abuse. Despite the court's trepidation during trial, and the court believes the trial transcript will demonstrate, the court routinely allowed J. Hatch to provide substantial and likely cumulative evidence and testimony concerning J. Hatch's theory that Bieda suffered from Munchausen's system by proxy, because it gave context to how Maya Kowalski presented to J. Hatch in October 2016 and had some probative value on the wrongful death and survivor claims. Plaintiff objected to the court allowing this to the point where plaintiffs often complained that J. Hatch was used in Chapter 39 as both a sword and shield, which is a perfectly valid complaint because you shouldn't be allowed to have it both ways. Right? You shouldn't be allowed to have it both ways. If you bring it in, it's in for everybody. Right? That's the thing. You shouldn't be allowed to have it both ways. So I'd be complaining too. The court also suspects the trial transcript will confirm that the court excluded much more of plaintiff's efforts to present the relevant materials than the court excluded from J. Hatch's request. After all said and done, though, even under J. Hatch's requested more generous scope of immunity, the reality remains that J. Hatch battered Maya on at least 2 separate occasions, which do not result from the dependency court proceedings. They falsely imprisoned Maya. They inflicted emotional distress on Maya, inflicted emotional distress on Bieda, that they submitted fraudulent bills and committed medical malpractice, none of which was required by the dependency court proceedings. Consistent with it, we're protecting the mandatory reporter theme. J. Hatch continues its motion with the sky is falling public policy argument, which is more appropriate for the legislature. If the judgment is not set aside, no hospital in Florida will be willing to keep a child in DCF custody at its facility once the child is ready to be discharged with foster care. Sure they will. Just follow the law. Just stick to the order, man. Just follow the law. So if other hospitals are dissuaded from breaking the law, that'll be fine by me. The court contends that the legislature adopted sections do not immunize a hospital that intentionally harms a child. That does seem unlikely. The court further contends the legislature did not immunize a hospital from medical malpractice or fraudulent billing, which also seems unlikely. The court denies J. Hatch's request to expand the scope of immunity. As does Section 2D, the addition of time. Prior to trial, the court announced it would be limiting the time of the attorneys to present evidence and testimony, whether direct or cross. This time allocation excluded opening statements and closing arguments, as well as legal arguments that remain outside the presence of the jury. The court believes plaintiffs requested 100 hours per side, and J. Hatch requested 60 hours. The court originally sought to allocate each side 50 hours before allowing 55. During trial, the court made 2 small alterations. The first time alteration occurred before plaintiffs rested their case in chief. The court awarded each side an additional 4 hours based on the many questions the jury asked. The court, in arriving at the 55-hour time allocation, had not anticipated the substantial expenditure of time due to many jury questions, as well as the attorney's follow-up of those questions, and routinely a second and sometimes third round of questions with additional follow-up. The court reached its 4-hour award on the court's projection of the amount of time each side would have to expend in follow-up. The court recalls J. Hatch objecting to and indicating if it had additional questions for witness already appearing, although J. Hatch did not advise the court concurrently that it did. Regardless, the court told J. Hatch it could call any of the individuals who had already testified if they had any additional questions. So it's like, if you want to recall them, that's cool with me. Fine. To the court's knowledge, J. Hatch did not accept the court's invitation. So they're like, we could have asked more questions of our witnesses. Cool, you want to call them back? That's fine. The second time alteration was near the end of the case, during J. Hatch's case in chief. Recall cross-examination was included in the parties' time allocation. Plaintiff identified that they were nearly out of time, they still had non-cumulative evidence to address, and they had been efficient with their time. The court ultimately granted an additional 2.5 hours for use in cross-examination during J. Hatch's case in chief, which would not carry over to rebuttal. The court also granted plaintiff a total of 2.5 hours for rebuttal. The court made the assessment because when it evaluated over a 2-month trial, plaintiff for the most part were generally efficient with their time, especially after the court observed and commented on real time any perceived slowness. While the transcript was being prepared, will actually reflect the time consumed announced by the court believes plaintiffs used 60 hours of trial time in its case in chief and cross-examination. Plaintiff also used 2 hours in his rebuttal case. Thus, plaintiffs were 7 hours over the original allocation and 2 hours over what J. Hatch originally proposed. To put 7 hours of context, there'll be less than 2 trial days before the jury, as the court attempted to have 4 to 5 hours of court time in the jury's presence each day. The court cannot agree that J. Hatch was prejudiced because the case went to the last day the court announced to the prospective jurors in September. During the trial, the court allowed days off requests by the parties and allowed the jury to leave early on other days, based in part on how the trial was progressing. The court also allowed parties to make lengthier legal arguments, together with many requests to reconsider. The point is, the court consciously or continuously was evaluating the time consumption and was sensitive to both sides' contemporaneous discussion of time needs as it occurred and what the parties were then forecasting. If time were truly becoming an issue for either side, the court would have trimmed days off, trimmed the length of argument, worked earlier and longer, and otherwise would have addressed whatever the parties said they truly needed. And if truly necessary and certainly not optimal, the court could have extended the trial into the following week as a last resort. But the party would have had to discuss the issue in real time with the court to give the court opportunity to address. So you have to ask or you can't complain. Right? You have to ask or you can't complain. You use it or you lose it, baby. You use it or you lose it. So if your issue was, we're coming up to the deadline and we need more time, you use it or you lose it. You didn't ask, so go away. The court, in granting this extra time, did not adversely impact J. Hatch, especially when the court gave J. Hatch additional time and allowed J. Hatch to recall any person they felt they needed to. Further, the court believes the trial transcript will not reveal J. Hatch contending they were unable to present substantial evidence it wished to be present due to a lack of time. And even if it had, by the way, the court, of course, has control over its court. So if the court puts you on a clock, any kind of reasonable clock, this is how much time you have. We need more, too bad. As long as they're fair about it, right? As long as they're fair and it's anything approaching reasonable for the case. The clock is the best invention ever. Team chess clock through and through, forever, man. Team chess clock forever. All right, as to Maya Kowalski's intentional tort claims. J. Hatch, in its motion, raises multiple claims concerning intentional torts. The jury found J. Hatch to have committed against her. J. Hatch amalgamates all damages for all claimants, for all disparate claims, into a single number, without regard to separate conduct occurring at separate times in separate counts. By commingling multiple claimants' awards for multiple claims, ignores the jury's specific words by claim and claimant. As it relates to Maya Kowalski's intentional tort claim, the jury found the following numbers, which we've discussed before. From false imprisonment and battery, the jury awarded the following numbers as the punitive. Put separately in context, these numbers do not reflect J. Hatch's contention of an unbridled jury that ran amok. Okay. I mean, you could certainly disagree with the conclusion, and there is a bit of an ultimate legal issue here that's beyond the pure fact of it, because there's not really there's really not a dispute of fact in this respect. I mean, the jury awarded what it awarded, so there's sort of a pure issue of law at the end of it, and so you could disagree without really any deference to the trial court if you wanted to. Of course, you'd have to disagree for legally sound reasons. You can't just disagree for the hell of it. But if the law is the law, right? So, the jury's restraint is particularly observable in that the 3 punitive damage awards, which J. Hatch also challenges. The punitive damage awards do not exceed the statutory caps established by law, even though the jury made findings to permit them to be exceeded. Notably, J. Hatch, in Phase 2 evidence and closing arguments, convincingly and effectively communicated to the jury that every single dollar awarded as punitive damages would be a dollar unavailable for important cancer research or charity care, including care in Sarasota County. This argument resonated with the jury. I mean, maybe. Given the balance sheet and other evidence of net worth exceeding $1.2 billion introduced into evidence, the punitive damages awards were rather tempered between the need to punish and the consequences of others based on the punishment. If the jury were truly influenced by improper emotion instead of dispassionate evidence, it could have awarded $500 million or more without coming close to bankrupting. Jesus Christ. $500 million appeared. But it did not. Instead, the award meaningfully but not deliberating amount. Well, the judge certainly thinks that the amounts are well within the realm of reason, so okay. Maybe the judge expressing some thoughts on the issue finally. Oh, Lord. The court is aware that J. Hatch, throughout its motion, raised multiple alternative arguments under different standards. And the court has reviewed each separate argument in context under its standard. And the court is only making a few comments in response to certain arguments. There's certainly no need by the court to add what's already been said previously by the court, the jury, and plaintiffs in their response. As it relates to false imprisonment claim, J. Hatch did not raise and therefore waived the 24-hour claim, which it appears to concede it did not assert. Even if it were not waived, it would have not mattered, given that it was more than 24 hours. As the court has discussed, the law grants 24 hours to act in which J. Hatch may have been entitled to prevent discharge. So for 24 hours, the hospital can say no. We'd like to take our child home. No. Okay, that's what the law says. For 24 hours, you can say no. But after the 24-hour period, they're therefore powerless. 24 hours and 1 minute, you have to say yes. The facts here reveal that the state initially declined to act. And there was evidence that J. Hatch continued the imprisonment more than 24 hours during the period. J. Hatch's post-trial attempt to invoke immunity for both 1 day as well as 1 week period is, of course, unavailing. As it relates to false imprisonment, J. Hatch states with respect to the EEG room by J. Hatch, that room has the capability to allow the EEG testing, which played no role in the case. The evidence at trial demonstrated it played a vital role. Recall there was evidence that J. Hatch purposely moved a portable commode just out of Maya's reach and then intentionally declined to help Maya in a timely fashion, causing her to defecate on herself. And there was more similar, egregious evidence as a trial as to this claim. Yep. Confusingly, J. Hatch contends that this process was not actual treatment of Maya. Yeah, I mean, pick a lane. Is it medical treatment or not? Pick a lane, J. Hatch has a real trouble picking a lane generally. We've seen this in a lot of their things, right? Is it CRPS or not? What did you think it was? Did you think it was CRPS or not? They won't take a position. Okay, was moving the commode part of a medical test? Would you like to take a position on that issue? Was it a medical test or was it not a medical test? J. Hatch seems to have lots of problems committing to a script. Yeah. I don't know whether it's a sick test in the first instance. It's just like take a lane. I mean, I can imagine a scenario when it would be a valid medical test. I could imagine a scenario. I'm not sure. Maybe I'm not a doctor, so I'm guessing from a somewhat reasonably well-informed layman, although not particularly about medicine, but I can at least in my mind imagine some scenario where this was valid medical test. But would you like to take a position at all? No? Okay. So, J. Hatch contends this process was not actually treatment. It was primarily a non-invasive diagnostic test. This is a running problem for J. Hatch during the trial. Either it was performing a medical procedure or it was not, and J. Hatch was never clear and definitive with the contrary to the jury. If it were medical, there should have been copious contemporaneous discussions in the medical chart. The jury saw that there was not. And while J. Hatch says the evidence is that she was not imprisoned in the EEG room, whereas here there's disputed evidence, this is of course up to the jury. As it relates to battery finding for hug, kisses, and petting, no means no. I mean, fair. I mean, yeah, no means no. I mean, that's fair. I can't dispute that. The court, though, pauses to note at page 81 of the motion, J. Hatch asserts that Maya claims that Miss Betty told her she wanted to be her mother. Assuming the testimony is true and Miss Betty's testimony is false, that statement is not battery, as it does not involve touching. It would have to rise to the level of extreme emotional distress to be relevant. I mean, strictly speaking, that's true, but it does. So that's a correct statement of law. It just does, though. This, of course, minimizes the testimony, which speaks to the intentional infliction of emotional distress. Yet J. Hatch discusses in the context of battery, saying the statement is not a battery if as is to domestic conduct. Well, it's not a battery. That's certainly true. I mean, yes. Yeah. This paragraph is an artful dodge of the evidence because J. Hatch then ignores the evidence that J. Hatch purposefully was trying to emotionally alienate Maya from their mother. Telling Maya her mother was dangerous, telling Maya repeatedly that someone else was going to be her mother was wrong. Was it, though? Was it wrong? I mean, who among us hasn't done this, right? Who among us hasn't done this? Those without sin, cast the first stone. Who among us has not told a child that their mother is dangerous and we were going to be their new parent now? I mean, it happens all the time, right? That's just a normal thing people do, man. Why are we blaming Johns Hopkins, right? Yeah. The court understands that healthcare providers at J. Hatch, to their core, believed that Maya was not safe at Beata's presence, and the law permitted them to share those concerns in the abuse hotline report and to the dependency court. They should have kept their actions there, but there was evidence they did not. And there was evidence from which the jury could find J. Hatch's hubris, that's a pretty good word for it, in engaging in conduct to Maya's face that J. Hatch purportedly purposefully designed to destroy Maya and her relationship with her mother. I mean, that's fair. Yeah. Hubris is a pretty good word for J. Hatch's many sins. J. Hatch, in pages of his motions, raised multiple claims concerning the jury's medical malpractice findings. As the one subclaim, J. Hatch discusses the role of Dr. Sally Smith. The jury found that she was J. Hatch's apparent agent. J. Hatch, for its part, disagrees. Dr. Sally Smith served at least two separate capacities with respect to Maya. First, she was on staff at J. Hatch and consulted on Maya's case. There was also evidence she directed Maya's care, which, that's a pretty big issue when it comes to medical malpractice. Second, she was at the same time the medical director of Pinellas County Child Protection Team, and certainly, but in all times, was performing her statutory role with respect to assisting DCF. Yeah. J. Hatch understandably attempted at trial to place all of Dr. Sally Smith's actions under her medical director status due to sovereign immunity. But because J. Hatch allowed Dr. Sally Smith to perform both roles simultaneously, there was no neat dividing line of her actions. Yeah, you can't kind of do that. That's nice and all, but no. Not so much, no. Not a lot of people in chat today, just incidentally. I don't know. Are you guys finding this interesting? The chat rate is just really, really low. And I like the engagement. So I'm not sure what that's all about. But, okay. There was evidence from which a jury could conclude that Dr. Sally Smith was J. Hatch's apparent agent, making it liable for malpractice associated with Maya's care and treatment. As the court is denying the various motions related to Dr. Sally Smith and consideration of the parties, Ruby gives $20 to say, Would you consider covering the last time J. Hatch Kowalski's argued before the 2nd District panel? Oral arguments by Zoom on YouTube. Great preview of Ma's appellate counsel. Educational opportunity on how appellate courts work. Maybe. Could be fun. Thank you. I'll consider it. Thank you. Yeah, the chat rate has just been really, really low. There's only been like one chat a minute, so I'm just like, is this boring? Is no one liking this? Because, I want to make sure things are, people like things. Lack of engagement suggests that people aren't interested, so maybe we're just tapped out on all things Maya. Maybe we shouldn't do anything more Maya related. I don't know. There was evidence from which the jury could conclude Dr. Sally Smith was J. Hatch's apparent agent, making it liable for malpractice associated with Maya's care and treatment. As the court is denying various motions relating to Dr. Sally Smith and consideration of the parties' prior notification of the court, the parties will need to advise the court on the issue of set-off and how set-off will be effectuated for the entry of treatment. It is definitely cold out there, that's for sure. Yeah, it's definitely cold out there. J. Hatch, in its motion, raises multiple issues concerning their survival and wrongful death claims brought by the personal representative of the estate of Bieda. The court agrees that the personal representative must elect between the jury's award in survival and the jury's award in wrongful death. And the personal representative has done so. The personal representative elected wrongful death. J. Hatch understandably challenges the court allowance of a claim involving a decedent's death by suicide. The claim is rare, like to the point of non-existence. Yeah, to the point of non-existence rare. I've never heard of it. Ever. So, non-existent, I think, is... Except in narrow circumstances not present here. Florida law does not permit recovery for a person's death by suicide due to a tortfeasor's negligence. Yeah. Yeah. In dismissing negligent theory of liability, the court held Florida law specifically provides there exists no liability for another's death by suicide absent a specific duty of care. In other words, the personal representative's efforts to hold J. Hatch liable for its alleged negligence associated with Bieda's death fail to state a cause of action because J. Hatch has no duty of care owed to Bieda. I mean, yeah, that's right. That's precisely why the court dismissed the negligent infliction of emotional distress claim. In the same order, though, the court distinguished negligent torts from intentional torts. $20 from Tai Mao, who says, I'm listening, just hard to find the energy to engage. Late, cold water and baby prep is eliminating my mind most of the time. Oddly, the listening to the law stuff focuses on my mind. Well, that's great. I'm glad to hear that. I hope everything works out well for you. In the same order, though, the court distinguished negligent torts from intentional torts by saying, the court's analysis of count 6B of why the personal representative cannot maintain a wrongful death cause of action for a negligent infliction of emotional distress does not necessarily apply equally to count 21B. That is so because the intentional count removed the duty element, which is the linchpin, which, I mean, fair enough. It certainly does remove the duty element. By 699 from Billy Momzilla, who says, we're a captive audience, well behaved. Well, I appreciate you being well behaved. I just want to make sure things are interesting and fun and enjoyable. And I appreciate you being here. The court previously explained the current state of Florida law on the viability of a wrongful death claim for death by suicide based on intentional infliction of emotional distress. Yeah, I mean, I don't know about that one. I guess we could go look up. So DIN 4128. So maybe we should pull DIN 2148 and read the court's analysis. That might be good for a future stream if people are interested. It would be interesting to see the court's analysis of the viability of the claim, because I have my serious doubts. We'll see if the court can convince me. So if there's enough interest, maybe we'll go back and read DIN 4128. That's the construction of law the court used in formulating the jury's instructions. The court understands J. Hatch disagrees the law could make it 100% liable for another's death by suicide based on potential conduct. The court recognizes the situation as rare, and the few cases remotely discussing the situation, most are out of state. Yeah. I don't know. To summarize, the court, I have my doubts. I'm skeptical. To summarize the court's view, Florida law permits recovery against an actor for an actor's intentional conduct that either was a substantial factor in causing the decedent's death by suicide or created in the decedent an uncontrollable impulse to die by suicide. Yeah, I'm not even sure. Okay. For a claimant to recover, the claimant does not need to show the actor specifically intended for a decedent to die by suicide. Yeah, I'm not sure about that. I'm also not sure what creating in the mind of another an uncontrollable impulse to die by suicide would be. An uncontrollable impulse. The jury incidentally found that in this case, and I'm still skeptical of it. The jury in this case agreed both theories exist, which seemed questionable as to theory 2. As a matter of fact, the court does not alter its view of Florida law on the topic and declines to eliminate the cause of action. Yeah, we'll see what the Court of Appeals does in the future. The court in this case agreed both theories exist. The court does not alter its view of Florida law on the topic and declines to eliminate the cause of action. Would one of my mods check and see if DIN 4128 is available somewhere? Could they download it from the Sarasota court website and let me know how long it is? Probably pretty lengthy, but I'd be interested to possibly cover it. So could someone please look into that and put it in YouTube in the mod chat or something for DIN 21 or DIN 4128? With few exceptions, the court disagrees with J. Hatch's contention concerning excessiveness of the verdict associated with damages awarded for the wrongful death. The fact that damage awarded is large does not itself render it excessive, nor does it indicate the jury was motivated by improper considerations in arriving at the award. A verdict should only be disturbed when so inordinately large as obviously exceed the maximum limit. Okay. The relevant law directs the court upon proper motion to review the amount of the award, determine if it's excessive in light of the facts and circumstances which were presented to the trier of fact. In performing the analysis, the legislature set forth the criteria the court must consider. The 11th Circuit's decision provides a good review of Florida law on the issue of reduction. The jury's non-economic award due to his mother's death. The jury awarded Jack Kowalski $50 million in non-economic damages for his wife's death. The jury also awarded each child $18 million in non-economic damages. The total non-economic damage award for the mother's death was $86 million. The court concludes that no reduction is required in consideration of the relevant factors. The court also rejects J. Hatch's efforts to compare this case to tobacco cases under the reasoning of Curvin. Instead, this case was simply different than those cases, and the comparison is unavailing. Yeah, there is not a lot of great comparisons based on what the parties cited. I tend to agree. Factor D, though, is complicated, though is implicated. The relevant law requires the court to evaluate whether the amount award bears a reasonable relation to the amount of damages proved and the injury suffered. Super Chat for $10 says, "For me, I'm not chatting because I'm paying attention to the reading. Many live comments have said similar. Very good." Okay, fair enough. When the award exceeds a maximum amount by which the jury may operate, the verdict should be reduced to the highest amount for which the jury could have properly awarded. In doing so, the court is not saying the amount it would have awarded. Instead, the court simply determines the outer limit of discretion. The question of how to compensate a claimant for a human non-economic loss always comes down to a question of money. The court has heard arguments for both sides in this case and other cases concerning the propriety of awarding money to compensate for non-economic damages. But Florida law, like the law of all common law jurisdictions, has not found a better way. I mean, fair enough, right? The court suspects any claimant would say that they would rather have the decedent alive with them instead of X or Y dollars. Although with these amounts, probably someone would think about it twice, to be honest. And the court is aware of the age-old discussion of the adequacy of standard jury instructions on non-economic damages. The reality is the jury is permitted to determine an amount that is fair and just in light of the evidence subject to the legislature's command for the court to evaluate for, among other things, excessiveness. Kestrel, how long is it? As relates to remitterer, perhaps the system may seem arbitrary, especially when the court remits the jury award, but the law directs the court to do so in certain circumstances. Under these very unique circumstances, although strictly speaking, things can't be very unique, because things are either unique or not. If we want to be hyperbolically technically correct is the best kind of correct. So, yeah. Under these very unique circumstances, the court concludes the jury could properly award $18 million to each child and will deny remitterer. The $50 million award to Jack for non-economic, however, is excessive. Here, the highest amount to which the jury could have properly awarded as non-economic damages for Jack's loss was $24 million in consideration of the evidence. I'm not sure necessarily how they came up with $24 million, but okay. But all right. The court therefore will remit the $50 million for Jack by $26 million to $24 million. In total, the non-economic damage award is $16 million in aggregate. Yeah, I'm not quite sure how the judge came up with $24 million particularly, but okay, that's what the judge said, so fine. So a $26 million reduction. Oh, it's only 26 pages long? We might try to squeeze it in tonight, Kestrel. Yeah, we might try to squeeze it in if it's only 26 pages. Probably 23 pages of text. We might try to squeeze it in. We'll see what our energy level looks like at the end of the stream and see if we can squeeze in an additional 23 pages of analysis. But only if you guys are really, really good and you help support the channel and stuff. You guys can vote with your dollars about whether you want to see it. We'll see. I'm not beyond trading my services for pay. The jury awarded Jack Kowalski $18 million in economic damages for Beata's death. The jury also awarded each child $2 million in economic damages. The jury also awarded the estate some money. The total economic damages is $22 million and change. The court concludes the relevant law did not require a remitterer. The evidence of the mother's economic contribution after consumption, together with her services provided to the survivors, cannot support $22.7 million. Okay. Based on evidence, the surplus of Beata Kowalski's earnings together with the replacement cost of her services to her husband and children, and assuming a generous investment return, would be in the low $6 million range in the aggregate, which is almost the same maximum that J-Hatch suggested in its motion. Okay. So we're going to reduce that amount too. As a reminder, a remitterer does not examine probability. Instead, a remitterer examines the highest permissible range with which the jury could operate. Under the evidence presented to the jury, the highest amount the jury could have properly awarded as economic damages for Jack was $2 million, for Maya $1.75, and for Kyle $1.75. The court leaves the $600,000 award to the estate undisturbed. Again, this amount is not necessarily what the court would have awarded. Instead, it's simply the outer limit. The court therefore remits $18 million to $16 million. The court remits $2 million to $1.75. The court remits $2 million to $1.75. And we do have those reductions. So. And we also have this one here, this $22 million reduced to $6. So we do have some reductions. listen, if you stream it on OnlyFans, I've definitely considered it before. Just to put it on OnlyFans. I'm not sure what it would actually take to stream this on OnlyFans, but that would be hilarious. We should do it just for the hell of it. I should absolutely start streaming this to OnlyFans. This would be great. I need to figure out how to do that. We'll totally do it. Just because we can. Why not? Yeah. Uncivil Law gets an OnlyFans account. That'd be great. Yeah. Yeah, you're right. The two there's a typo, right? The court will reduce the $22 million by $250,000 million. Yeah, you're right. There's a typo. Yeah. Hot, steamy lawyer action, right? Well, so we'll have to come up with like really clickbaity titles, like hot, steamy lawyer. Yeah, we'll have to come up with all kinds of like, shit. But yeah, it could be fun. Oh Lord. Oh, I mean, we might as well give those hoes a good legal education, right? Lol. Jay Hatch, in its pages of the motion, raises issues with the juror buildings of fraud findings. The court notes that the jury in other counts awards Jack a little more than $1.5 million in non-economic damages associated with Maya's care. At questions 32 and 33 on the verdict, the jury awarded Jack $3 million and $2 million, respectively, for various economic damages. Oh, the collabs. The collabs from OnlyFans could be really interesting. Holy shit. Wow. There's so many ways this can go, man. So many ways this can go. The court agrees that little more than the $1.5 million in direct economic damage Jack Kowalski individually received. It's the maximum award Jack Kowalski individually could receive for all these non-economic damages. The $5 million awarded for damages in question 32 and 33 on the verdict form exceeds the maximum permissible range the jury could properly award. For this reason, the court will remit $3 million from the question to $1 and remit $2 million to $1. Yeah. Just put single attorney in the title and watch the dollars come in. I wonder if I can set it up midstream. We might do it. I'm just so tempted by this possibility. My mods can let me know whether they think this is a good idea in YouTube mod chat. Is this a good idea or the worst idea I've ever had? So, anyways, the motions for remitterers granted part denied report, and the motion for remitter associated with $50 million is granted, reducing $50 million by $26 million to $24 million. The remitter for $18 million is granted, remitting $18 million to $16 million. The court remitter for $2 million is granted. The court will reduce $2 million to $1.75. The court for remitterer associated with $2 million, a verdict for Kyle Kowalski due to Beta's death is granted. The court will remit $2 million by $250,000. The motion for remitter associated with $3 million is reduced by $3 million to $1. The motion for $2 million is reduced by $2 million to $1. Pursuant to relevant law, the personal representative has 15 days to reject the remitterer and elect a new trial on damages, which I'm not sure I would do. So, do you really want to go through this again? The personal representative may separately elect as each ruling. Failure to file an election within time constitutes acceptance. Of course, if the personal representative is accepting, counsel can notify the court prior to the expiration so the court can then proceed to enter judgment. So that's why no judgment was entered. Pursuant to law, Jack individually has 15 days with which to reject or accept and may reject or accept as required. The parties shall advise possible how to effectuate set-off with respect to Dr. Sally Smith's settlement. This order is not the judgment or judgments as does not complete the judicial labor remaining in the case. The remitter election periods have not expired, and the mechanics of set off have not been resolved. After those two issues have been resolved, the court will enter judgments, and if elected by the personal representative Jack Kowalski, individually or both, a new trial, any rejected remitted claims. The parties will email the court's judicial assistants one or more judgments in ward that effectuate the jury's verdicts as discussed. If the parties are unable to agree, each side may present. The court restricts this and further and so forth. Okay, great. And then we have a mediation that was ordered. So we will I don't know why, because there's not going to be any substantive mediation, but we're going to order it anyway. You understand the reductions? The court found them not sustainable at law. That's the short version. How much total was reduced? I'd have to do the math. Yeah, some. And probably it's below 200 million now, if I had to do the math off the top of my head. So probably, yeah, it's probably closer to 200 or below 200 million now. Anyways, don't ask me to do math. I know it's not 4128. I'm doing things over here. You may want to read this before. Read what before? What am I doing wrong now? How have I disappointed you? John Common gives $5 to say for your OnlyFans fun. Glad I was able to help. Thank you. Yeah. What am I doing wrong now? Have I seen the Not Safe for Children South Park special? I think I have. Yeah. I don't know what you guys want from me. I'm moving on. Before the court is the court's motion to refer the parties to mediation. The court during the hearing discussed the concept of referring the parties back to mediation. The court has now ruled on all post-verdict motions and will soon be entering one or more judgments. The court anticipates plans to file motions for cost, and if there are any legal basis, a motion for fees. On the court's own motion, the court directs the parties to mediate all motions for costs or attorney's fees, both as well as disagreements existing between them. The court anticipates the parties may need at least 2 separate mediation sessions. The court leave it to the parties and mediator to determine if the second day of mediation is on the day immediately after the first, or if some interval is best. The following conditions must be observed. The mediation must be in person. For plaintiffs, both Maya and Jack must be present. The child can also attend, but he doesn't have to be there. For defendant Johns Hopkins All Children's Hospital, either the president, chief executive officer of JHatch, or a senior executive of JHatch who reports directly to the president must be present, as well as any client representative JHatch elects. Nothing in this order precludes a senior executive of Johns Hopkins Health from also attending, and if attending, JHatch's participation will be covered by mediation privilege. So if the corporation as a whole wants to attend. Court strongly encourages the senior corporation attendance and may assist with settlement discussions. Court does not believe they filed a motion for attorney's fees or costs following dismissal. If correct, the court understands and acknowledges they would no longer be a party, and thus the court would no longer have jurisdiction in the proceeding to require them to attend. They'd be welcome, but is voluntary. Okay. A high-level representative of each insurance carrier or entity operating like an insurance carrier that may have liability to provide payment for any portion of the impending judgment must attend. The representative must have full authority to resolve the case up to the face amount of the judgment, plus accrued interest, or if that amount exceeds the policy limits, up to the face amount of the policy. Critically, this representative must have full authority without the need to contact any other person or consult any committee. To be clear, this attendance requirement includes any excess carrier or other entity that operates like an insurance company. If there's been allegations of bad faith with respect to insurance coverage, the carrier must also have separate counsel and a separate representative present during mediation to address and resolve any bad faith claims. Yeah, I got the long thing. I got a long thing. Got 200 something pages of documents, which I mentioned at the top. We'll try to skim through. It's a lot. I'm not sure it's incidentally the IJ, because I scanned the entire document and I didn't see the word judgment appear. I didn't see the words immediate judgment appear anywhere in the total pages. So I'm not sure it's in the immediate judgment, because I didn't find the words immediate judgment anywhere in the entire pages you sent me. So I don't know if I'm missing it or something, but I couldn't find it. The first day of mediation must occur on or before April 15th. The mediation must conclude no later than May 13th. The court, at this request of one of the parties, may extend the hour deadline. How the deadline can only be extended by court order and not by agreement of the parties or declaration by the mediator. The parties must jointly select the mediator no 10 days later from the date. If the parties do not select a mediator, the court will proceed to appoint one. Okay. All right, fine. Is it normal to appoint mediation at this juncture? Not particularly, no. I'm not sure what we're doing at this point. With respect to sanction requests, the court simply asks for citation to any and all outstanding requests. So I'll just summarize the page. Please give us all the things. Great. That brings us to the end of that. All right. And then I've got you guys, some of you guys sent me a 240-page PDF, which is all the, hold on. Yeah. So some of you guys sent me a 240-page PDF, which is apparently a lot of history concerning J Hatch and various actions that have been taken against them. But the word jeopardy didn't appear once in the entire 240 pages. So, yeah, I know. I searched the entire document for jeopardy and it didn't appear once in the entire 240 pages. So, unless you guys know where it is or I'm missing something, you know. Ooh. Is that the entire appellate court ruling on immunity? It seems to be just all relevant files. Yeah, I don't think it's the immediate jeopardy. It's just a whole bunch of things that concern J Hatch and various things they've been done. It's not the I got a notice from my workout app. I'm not sure exactly what this means, but it says my 90M strength score for shoulders was higher than a giant sequoia in space, which apparently landed me in the top 7% of people who logged in the workout app. So apparently, whatever score I did in my shoulders puts me in the top 5%, top 7% of all people who work out using this app. Who knew I was that strong? Kick ass. Although I got humbled today at the gym. I got humbled hard today at the gym. So I was doing chest fly, and I was doing chest fly at like 160 and then I think 175 pounds. And there was this guy next to me who was clearly older than me who was maxing it out. He was doing flies at 290 pounds. You know, he literally had the pin in the bottom of the machine. He was doing chest flies at 290 pounds. And so I actually said, way to go. I talked to him for a little bit, you know, because I was impressed. And he said, oh, I'm 63. So it's hard for me to do this now. And I'm like, well, I'm 43. Or he said I'm 62 or something like that. And it's hard for me to do. It's like, well, I'm 43 and I can't do it either. Well, you have 20 years to go, young sir. This guy's kicking my ass. He's 20 years older than me, and he's doing 290-pound chest flies. 290 pounds. On the machine fly. On the machine fly. So yes, there's a pulley, but still. Yeah, I mean, it's on machine fly, so there's a pulley, but yeah, I mean, that's I'm just saying. I'm just saying. All right, so let's read this other thing because I don't see what this 240 thing page thing. It doesn't seem to have the immediate jeopardy. So a bunch of people sent to me, but it doesn't seem to have anything. Yeah. Is Jack LaLanne? Yeah, I guess so, right? So all right, let's take a look at this. This isn't right. Oh, maybe it is right. Maybe it's a hearing relating to it. Okay. So yeah, this might be right. Hold on one second. All right, so it looks like it's a court hearing transcript. Okay, excerpts of the proceedings. Okay, for this 4128. Okay. I know I could max the machine. I'm just saying I'm getting my ass handed to me right now. That's all I'm trying to say. That's all I'm trying to say. If it makes you guys feel better, I maxed the back extension machine. Does that make you guys feel better? I max the back extension machine. I'm doing 300-pound back extensions. Does that make you guys feel better? I'm strong in some ways, guys. I'm just telling you what I got. All right. I do 500-pound leg presses. That's pretty good. No, we don't have the IJ. We don't have the IJ. So sadly no. All right. Let's all right, let's open this thing up and look at this transcript. Snickers bar? Man, I can't make you guys happy sometimes, I swear to God. How much weight I left on the same gym machine? I told you he was doing. I told you he was doing 290 pounds on the fly, and I was doing 175. So I left 120 pounds on the machine. Math. All right. No. So here's this hearing transcript, which is apparently the den that they were citing. Yeah. Since I'm from Mexico, I don't understand pounds, just kilos. Well, there's 2.2 pounds per kilo, right? So divide by half, and you're close. Anyways, let's read this thing before I get too lost in fitness conversation. Yeah, on the press side, engagement is up. That's true, man. All I have to do is talk about my workout, and suddenly people have opinions. That's fair. All right. Anyways, so here's apparently the court proceedings. So let's see what they say. So here's an excerpt recording the thing. The court says under Florida law, Florida in a negligence contract has a really limit based on duty, with any recovery for death by suicide in a negligence contract. Well, we don't need to know as to negligence because they dismissed it. So they cite Paddock. It was Fifth Circuit or Fifth Florida Circuit. The court says there's a number of cases going back to the intentional infliction of emotional distress that talked about in some way, shape, or form death by suicide and recovery. Now, when I say there are any number of cases, the universe of the cases is small. I think the lawyers have probably cited or discussed most, if not all of them, or read all those because they've been cited also certain other aspects. I'm going to start with Tate, which is California, where also a separate citation is a different citation. And the case is from 1960 in California, 65 years ago. Probably is the most extensive discussion on recovery of death by suicide. It's important to remember that this case was on a motion to dismiss stage, and there was effectively two counts. One was intentional infliction of emotional distress, and the second count was negligence. There was also specifically no allegation the defendant in that case intended to cause the decedent to die by suicide. So there's no specific intent alleged that the defendant intended for the decedent's cause to cause the decedent to die by suicide. In reading the case, I think it becomes important to separate out discussions that Tate Court had with respect to intentional infliction from the discussion they had to negligence. With respect to intentional, there was this core, and this is a statement particularly that they say, consequently, you believe in a case where the defendant intended by his conduct to cause serious mental stress or serious physical suffering, and then it goes so forth. It looks to me like the court was talking about two different variants of recovery under intentional infliction of emotional distress based on death by suicide. One is I'll call it shorthand, the substantial factor in bringing about the suicide. And the second one, the case law is kind of termed irresistible impulse. That isn't the exact language used by the Tate Court, but it's what other courts have ultimately called it. And when I look at the phrase whether suicide was committed in a state of insanity or responsive to an irresistible impulse or not. Now, obviously, it's probably not the most artfully drawn discussion of whether there are one or two different theories of recovery under intentional infliction. But as I read the Tate case, and other courts have read it this way as well, I read the Tate case as you can recover, and this is, by the way, all California law. So just incidentally for what it's worth. So it's persuasive authority at best, right? As we're trying to figure out what the law is in Florida. I read the Tate case as you can recover, or a plaintiff can recover under intentional infliction, even without showing of an irresistible impulse. In other words, you'd have to show the substantial factor. The conduct was a substantial factor in bringing about the suicide, but you don't need to show irresistible impulse, which also means under the Tate case, decedent does not have to have a mental illness. Okay. I referenced a few moments ago that other courts have recognized the fact that Tate appears to have two different discussions or two different theories. The next one I refer to a Mississippi case, which is also not Florida, 1968 from the Supreme Court of Mississippi. In Mississippi, there are two different variants. In Mississippi, set back in 68, since plaintiff's evidence supports these factors, irresistible impulse, we do not reach the additional impulse considered in Tate, which allowed recovery for suicide by intentional tort, if the mental stress from which defendant was inflicted was a substantial cause of suicide, even if the decedent was aware of his act and was not responding to it, irresistible impulse. So while Mississippi did not say that you could recover in Mississippi for a substantial cause, the Mississippi court recognized that Tate recognized these two different variants. My reading of New Hampshire law, still not Florida, from 1985 decision by the Supreme Court of New Hampshire, refers to proof of substantial causation by headnotes. Intentionally wronged a victim, and this intentional conduct caused severe emotional distress in his victim, which was a substantial factor. I'm having a sneaking suspicion we're going to have to go read Tate. It seems like everyone's citing Tate in a game of telephone. I have a sneaking suspicion we're going to have to go back and read Tate the way this is going. Because it seems like Tate is the one everyone's citing. All right. Which the Supreme Court or the Florida court notes was on a motion to dismiss stage. This is a weird form of precedence, man. This is interesting. It's on a motion to dismiss stage, ruling that somehow becomes apparently the dominant law in the nation on the subject. Okay, that's different. It's definitely the IJ. Just show me, where does it say immediate jeopardy? Do that for me, Ashley, please. I'm sorry for being a little bit sharp. I apologize. I shouldn't have been as sharp. That was my bad. I'm sorry for having a temper. I apologize, Ashley. I shouldn't have said that. I'm sorry. Could you please show me on what page it uses the phrase immediate jeopardy? It should be there. What page does it actually use the phrase immediate jeopardy? That would be helpful. Thank you. Sorry for my temper. Sometimes I get a little bit frustrated. I apologize. Another one from the New Hampshire's case, I think, goes through the chronological liability of New Hampshire about intentional infliction of emotional distress and recovery for death by suicide. Will I be covering Rust? No. I think I referenced a Wyoming case from the Supreme Court of Wyoming. It talks about the pleadings in that case referring to a substantial factor bringing about suicide. And so under the pleadings in Wyoming law was based on a substantial factor and not on irresistible impulse. Now I belabor that discussion from Tate to help inform my understanding of what Tate really talked about. The Florida court has specifically adopted Tate, and that's from Nelson. A Florida court has adopted Tate. A Florida court has adopted Tate. Where the case is right this second, I don't know. My recollection of the case, the first district did specifically adopt Tate, but discussing Tate, it kept referring to passages having to do with negligence. That's super helpful. My best reading of the case is that they were not addressing intentional tort, did not address that issue in Nelson. So therefore, Nelson is not binding on me for the issue, which, yeah. Having said that, though, I do think and do conclude Tate's discussion of the different theories, if you will, about how you can recover intentional infliction. The irresistible impulse as well as substantial factor both are valid means of recovering under evolving common law. Okay. Yeah. You weren't even that hyped? I don't mind talking about the IJ. I just didn't see it where it was talking about it. I'll talk about anything relevant. It just didn't appear to be the IJ. I'm just like, where does it say immediate jeopardy anywhere in those 200 pages? I did a control F and I couldn't find it. So just point me to the thing that shows it's in fact the IJ, please. Thank you. Yeah, we'll look up Tate in a second. All right, so I come to the conclusion Nelson's not binding. Having said that, though, Tate's discussion of different theories, I think it's parenthetical. I don't think it matters, but Tate did make a point a couple times that its reasoning was based on the fact that California did not criminalize the actor who died by suicide, did not criminalize the conduct. Now, there might be criminal conduct penalties associated with those who may assist in suicide, but not having to do with the actual person, the decedent, who attempts to commit suicide, or the person did not fulfill the self-murder, they were not criminally prosecuted. Yeah. Legal arguments over intentional infliction of emotional stress goes into great detail on day 16 of the trial. But I'm reading from the courts. They cited this. This is what the court cited. This was their citation in their own decision. So I'm going to go with what the court cited. It says imminent threat to patient safety. On what page? On what page does it say that? Just tell me what page. There might be criminal processes associated with those who assist. Okay, I did not find Florida statute that criminally criminalizes the behavior of an actor who attempts self-murder. There are crimes that prohibit, euthanasia or assisting. There is also a statute which talks about publication of a self-murder. and prohibits the commercialization of that. Balancing Florida statute make it a crime to attempt self-murder. Will someone please time out 20th Century Fox? Because I'm pissed. You emailed me the 33-page one. Okay, hold on. Okay, Ashley, you email me JHATCH files, which was a 240-page document. And you sent me the same thing again, which is a 240-page document. I did not receive from you an email a 33-page document. I received from you JHATCH files.pdf, and then the same thing again. In the 33-page one, this one you just sent me is 26 pages long. Excerpts of a jury trial, Judge Carroll's statement. You haven't emailed me a 33-page document. All right, so here's one that's 33 pages. This one we've seen before. This one is the summary of the thing, I think. I feel like we've seen this before, though. I don't think this is the IJ. I think it's just a report about the IJ. I don't think it is the IJ. Why does Stream Elements keep posting? Because I ask it to. It's on a timer because there's various messages I wanted to repeat on a timer interval. You think this is the IJ? Fine. Okay, fine. All right. Here apparently is the IJ. Yeah, what you have is a report on the IJ, not the IJ itself. That's what I thought. It's a report on the IJ, not the IJ itself. We've seen this before. Yeah, we've seen this before. I don't think this is the IJ. I think it's a report on the IJ. Yeah. Yeah, it's from AHCA, which didn't issue the IJ. So I don't think it is the IJ. Can I go back to what I was doing now? Okay. That was the most frustrating thing in my recent life. I don't know how to deal with that. I don't know how to deal with that. I'm like, and also, by the way, not for nothing, but I just got the 33-page thing now. The one you sent me 8 minutes ago. So you said, so I don't see the other one that you sent me or sent me the other one before. You had sent me the one that was 200 something pages that didn't use the words immediate jeopardy once in 200 whatever pages. Didn't use the phrase immediate jeopardy once. You're like, I sent it to you. I sent it to you. Did you? Because I got the one you sent at 8:37 with the 33 pages. Where before did you send it to me? Where before did you send it to me? Then you're basically saying I missed something and you didn't send it to me. I'm completely no, I'm not okay. I'm pissed. And my eye hurts. I'm having an allergic reaction or something. I've disrupted my entire stream. Ghost hunting for something that didn't exist in the first place. And I'm a little bit irritated about it. All right. Now, the extent there might be a statute, my analysis might change. I'm just highlighting that because California made it a big point as to its rationale. So that's why I was looking at the issue additionally for Florida because it was an important one. The elements of intentional infliction of emotional distress, a good case, is something else. Elements stated cause of action for intentional infliction of emotional distress. The complaint must allege 4 elements, which I know what they are. This, of course, is very difficult and very high burn. True. In thinking about rules of law, I keep coming back to whether there must be shown irresistible impulse, or if there was circumstances so outrageous that if even an individual did not have mental illness or did not have some onset of irresistible impulse, could defend an intentional infliction case where the conduct is already outrageous to begin with, be liable for someone's death by suicide if the conduct could be shown to have some sort of substantial cause of death by suicide. I keep coming back to the conclusion that the Tate Court came back with, which is an acceptable mode of recovery. This feels like a very bad game of telephone that is happening right now. Yeah. Distracting uncivil when he's doing something it throws me way off track. Because now I have to go hunt this thing down. And it just leads to all kinds of problems. So it takes me off my game. I probably should just ignore I just should ignore the chat. I really should ignore the chat sometimes. But I don't like it when I make a mistake. I don't like it when I make a mistake. Someone's like, oh, you made a mistake. What did I? Just don't send me anything, Ashley. Just don't send me anything anymore. Thanks. We're good. We're good. Just don't email me anymore. That's great. Thanks. So my bottom line in summation conclusions as follows. One, I do not believe there is to be a showing that Beata suffered from any type of mental illness pre-existing. Two, I think the plaintiffs could show, if they present evidence, assuming they had evidence, that there was an irresistible impulse. I certainly could think of valid mode of recovery, but I also think there was another valid mode of recovery, which is substantial factor theory, which is also be valid. So, Mr. Alterman, I know Mr. Illegit is not here. I'll let Mr. Whitney perform, but given that I've now rattled on about 12 to 15, 20 minutes, do you have any further questions? Alter Band says, my biggest concern is the parties haven't even argued in either or two-prong approach. Try to figure out what we got to this point, how to explain the irresistible impulse concept. If that's sort of, we're going to equate substantial factor with this test to the point in time. I don't know, and I know in some ways in trial here, but I don't know how we're going to define substantial factor. That's a good point. Is it just going to be up in the air? Is it what it is? It seems to me substantial factor was only in suicide would be a definition, but I haven't yet tried to devise. I'm telling you my view of what I think the state of the law is. I'm certainly leaving it to lawyers to tell me specifically, like, if they only think there's going to be a certain theory, that's fine. But I see as Tate allowing either or. Yeah. From a 1960s California opinion? Oof. The theory is plaintiffs are going to go under irresistible impulse. All right, and then they discuss this some more. And it's just some more. Yeah, so now we need to go back to Tate. We need to go back to Tate 1960. All right. From the District Court of Appeal in 1960. Oof. So from an appellate court decision in California. I mean, as like the entire fundamental basis of what they say is a common law trend. Yeah. No, yeah. All right, let's take a look at this thing from let me print this to PDF and open it up in the PDF reader. Let's see. All right, let me do it this way. All right, so Tate from 1960 from California. See what this has to say on the issue from the California Court of Appeals. The California Court of Appeals in a later time would rule that bees are fish. So my respect for the California Court of Appeals leaves something to be desired right about now. Yeah, so the Florida Supreme Court is basically going to be asked if they like Tate or not. Basically, yeah, that's the sort of the bottom line. Do you like this? Do you like this case? Yeah. And the judge is trying to extend it out. And he has a Court of Appeals decision which kind of endorsed Tate as to its negligence holding, which I guess is something. Ugh. All right, so we'll skip all the facts because who cares? To suicide a common law, it's a felony. Yeah, to commit suicide was a crime. And so they're quoting from Blackstone's commentaries. What punishment can human laws inflict on one who's withdrawn himself from the reach? Yeah, so we're discussing the history of suicide being illegal. And then they note that suicide has never been illegal in California. It was only comparatively recent times any attempt was made to hold a defendant civilly liable for causing the death of another. All right, so liability for intentional injury causing suicide. The law has for a long time recognized the distinction between intentional and negligent torts, has generally recognized fewer defenses and been more inclined to find defense conduct was the legal cause of harm or torts intentional. Fair enough. Indeed, it appears that many limitations upon liability that are subsumed upon the doctrine of proximate cause. Yeah, that's one of the big issues. Proximate cause and actual cause is where this sort of all breaks down. Right? The proximate cause and actual cause, like, so you do a thing to a person, they kill themselves, but how did those two things link to each other? Right? How did the thing that you do cause the harm? So you have an actual cause and proximate cause problem, right? So yeah, the many limitations are subsumed on doctrine of proximate cause, as usually expounded in negligence, do not apply to intentional torts. Well, they kind of do. I mean, you don't normally think of it in explicitly those terms, but it kind of does, right? You don't normally think of proximate cause as a factor in an intentional tort, but it's got to be a concept that's buried in there. I mean, there's got to be a limitation to how deep your intentional torts can go. So yeah, I mean, I think it is sitting in the background, but it's not an explicit element. I'll give them that, and maybe it's less viable, but I wouldn't say it doesn't exist at all. The restatement of tort says if an actor's conduct is intended by him to bring about bodily harm to another, which the actor is privileged not to inflict, is the legal cause of any bodily harm of the type intended, which is a substantial factor. Well, I suppose that's true, but you've just basically defined it as proximate cause, so it's basically baked into the definition. So what's the difference? Tort is a weird word. No, it just means harm. It just means harm in French. It's French. Courts have imposed liability for intentionally subjecting a person to mental distress. In recent years, the courts have tended to recognize intentional infliction of emotional distress as a separate tort. Sure. And then they deal with intentional infliction of emotional distress as a generalized concept. And mental distress there too, which surely enough. In the past, it's been frequently been stated that the interest in emotional and mental tranquility is not one the law will protect from invasion. The restatement, however, recognized in many cases mental distress could be so intense it could be reasonably foreseen that illness or bodily harm might result. So the entire concept of intentional infliction of emotional distress is a relatively new tort. Okay. I guess people were hardier in the past. I wonder when intentional infliction of emotional distress was first recognized in American law. It doesn't sound like it was too long before 1960 or 1950. It doesn't sound like it was too. It sounds like it might be like early 20th century. Yeah. But it doesn't sound like it's this far back. Yeah. I'm taking advanced torts, and today we talk about different approaches, like Holmes' view of corrective justice. Sounds kick ass. That sounds fun. All right. One without privilege to do so intentionally causes severe emotional distress is liable for such distress and for bodily harm resulting from it. Okay. The interest in freedom from severe emotional stress is regarded as of significant importance to require others to refrain from conduct intended to invade it. Such conduct is tortious. The injury suffered by one whose interest is invaded is frequently far more serious to him than certain tortious invasions of the interest of bodily integrity and other legally protected interests. In the absence of a privilege, the actor's conduct has no social utility. No reason or policy requires such an act to be protected. Okay. There are persuasive arguments and analogies that support the recognition of a right to be free from serious, intentional, and unprivileged invasion of mental and emotional tranquility. If a cause of action is otherwise established is so that damages may be given for mental suffering naturally ensuing from the acts, and in the case of many torts, assault, battery, false imprisonment, defamation, mental suffering will frequently constitute the principal element of damages. In cases where mental suffering constitutes a major element, it is anomalous to deny recovery because the intentional misconduct fell short of producing injury. Okay, so you don't need physical injury in the case of intentional infliction. Okay, that works for me. Comment C succinctly states the distinction between intentional and negligence. The rule stated in the section is determining the causal relationship necessary to make the actor liable for bodily harm, which intends to inflict, differs in significant particulars from those which determine a causal relationship necessary to make the negligent actor liable from harm. First, in determining whether the actor's conduct is a substantial factor in bringing about the type of harm which he intended to inflict, no consideration is given to the fact that after the event it appears highly extraordinary. It should have brought about such a harm, or the actor's conduct has created a situation harmless, unless acted on by other forces which the actor is not responsible. Hmm. I'm not sure about that. Second, all it's necessary to make an actor liable under the rule is that his conduct is a substantial factor in bringing about the injury. There are no rules which relieve the actor from liability because of the manner in which his conduct has resulted in injury, such as where there's liability of negligent actor. Therefore, the fact that the actor's conduct becomes effective in harm only through intervention of new and independent forces for which the actor is not responsible is of no importance. That doesn't sound right. So, too, the fact that the operation of the new force was unexpected by the actor, even that it appears highly extraordinary that it operate, does not relieve the actor from liability. So, too, the wrongful character of the intervening force is of no moment. There's not so where the injury is brought about by intervening negligent act of a third person, but also where it's brought about by tortious criminal act of a third person, which itself is intended to bring harm, which is sustained. All right, so basically, we're trying to argue that if you do a thing intentionally, if you intentionally inflict, but it wouldn't cause harm, but for the addition of something that's outside your control. I don't know about that one, man. I don't know. I don't know about that one. Yeah, I'm not sure about that. I'd have to go back to. I'd have to go back to reread the restatement of torts, which I'm not going to do right now. This rabbit hole has to stop sometime. And also, incidentally, of course, the restatement of torts is not authoritative. So, even if the restatement of torts says that, the restatement of torts is not authoritative. The restatement of torts, at its best, and restatements, I like restatements. They're treatises. Restatement is a treatise. It's a hornbook. They're great. It's a summation of all law that kind of exists on a subject, but it is not authoritative. It is a learned compilation that is worthy of the consideration of any prudent lawyer. It will tell you where to go look. It will give you an outstanding summary of the law in a very quick fashion. So if you need to learn something you don't know as a lawyer, a treatise or a hornbook is a great place to go. Like if I need to learn a field of law I don't need to that I don't know in a hurry, and there's a treatise on it, fantastic, fantastic, right? But it's not authoritative. Now, that being the case, however, it is by no means unusual for courts to cite it. I'm just saying, like, it's not authoritative. So, Yeah. So it's like, first of all, I'm not necessarily sure that they're necessarily quoting the restatement correctly, because I always have to consider that possibility. This is why you always have to go back to the source material. So I'm not even sure necessarily they're quoting the restatement in a fair way. It's also possible they're taking the statements out of context. I've seen courts do that before. Definitely seen lawyers do it. I've seen courts do it before. So like, first I'd have to go back to see, is that really what the restatement really said? And then second of all, why is it saying that? Where is it coming from? And third, is it correct in this particular application? Right? So you can get deep on this stuff, when you really get into it. The clauses referred above are those dealing with proximate intervening cause. It made clear the notion of independent intervening cause has no place in the law of intentional tort, so long as there is a factual cause chain of causation. That doesn't sound right. That doesn't sound right, because that wouldn't even be true in criminal law. That doesn't sound right, right? I mean, if there's truly an independent intervening cause, that usually breaks the chain of law that usually breaks the chain for a crime. Let alone, so the idea that an independent intervening cause has no place in the chain of causation in torts seems wrong. It seems wrong. Do you know if Scottus is going to stream the oral argument for Chevron tomorrow? Oh yeah, they will, absolutely. And hopefully we can pick it up on Friday. Would be great if we have a transcript. I'd love to cover that case. Obviously. So definitely going to cover it soon. Yeah. Anyone else here an expert on torts? Anyone else here an expert on torts and the idea of like whether a intervening independent cause is enough to break the chain of causation in an intentional tort? I need like, who does intentional torts? There's not a lot of lawyers who do intentional torts. Lots of ones do negligence, but intentional torts, that's a relatively rare field. Who's an expert in this stuff? I need someone who's an expert in intentional torts. That's a relatively low level. It's a relatively few and far between specialty. Shit ton of negligent tort lawyers, not many of the intentional variety. Nor does foreseeability suicide a factor as indicated by the foregoing comments. In this connection, it's interesting to note that breaches of obligation other than contract, well, that's definitionally what a tort is, for a breach arising out of not contract, the measure of damage except where otherwise provided, the amount will compensate for all detriment, proximate cause. Now they're talking about proximate cause again. What? Ask a Canadian. No. I don't know anyone who knows this stuff. No one in, I can't think of, maybe Peter. Maybe Peter knows it. He's a plaintiff's lawyer. Maybe Peter. Other than Peter, I can't think of anyone who might have knowledge on this. This is, yeah. If not Peter, we're all fucked. Nor's foreseeability of society factors enabled from foregoing comments. In this connection, it's interesting to note civil code. Nor can be said acts of suicide should be a defense by analogy to the doctrine of contributory negligence. It's general that the state of contributory negligence of the plaintiff is no defense for an action of an intentional tort. Really? Okay. Consequently, believing a case where defendant intended by its conduct to cause serious mental distress or serious physical suffering has done so, such mental distress is shown by evidence to be a substantial factor in bringing about the suicide. The cause of action for wrongful death results whether or not the suicide was committed in a state of insanity or is irresistible impulse or not. The rule will not apply where the act of defendant was intentionally done, but there's no intent to cause injury. It is only applicable where the actor intended to cause injury and the injury is a substantial factor in bringing about the suicide. It is really a cause, in fact, of the suicide. Well, how would you determine that? Does not mean in every case where an actor. This does not mean in every case where the actor intentionally causes serious mental distress or physical suffering, and this is followed by suicide, the actor is necessarily liable. Why not? Why doesn't it mean that? The mental stress or physical suffering may not be in the particular case, as a matter of fact, a substantial factor. I mean, I'd have to really try to make it not at that point. There are a few. Okay. There are a few cases dealing with the question. A different case is contrary to our views. My opinion, while considering the result of torture, a man may kill himself. First says that if he does so deliberately, his act is an intervening act for which the defendant is not liable. And then that as the killing is a result of suicidal mania, such mania is not naturally a reasonable cause of the tort. This opinion, in our judgment, is wrong on both grounds. So there's a Court of Appeals decision from another California Supreme Court which went the other way. I'm not sure I believe any of this. I'm not sure I believe that I'm not sure that proximate cause isn't a concept in intentional tort. It is in crimes. I'm not sure that I'm sure that an independent intervening cause doesn't break the tort. It does in crimes. I'm not sure that if you accept the premise that not all mental anguish that then suicide follows how would you say the mental anguish didn't cause the suicide? I don't even know what that looks like. My brain hurts. The court also said that some other court. Wait, no, this is now, I think, a New York court. So this is coming from the Court of Appeals of New York that California is citing. So in a New York appellate court, the New York appellate court said that even in the case of intentional tort, damage must be proximately caused. Which, yeah. This latter statement was an unnecessary decision. As we see, not all the limitations on liability embodying the rules of proximate cause as developed in negligence cases are applicable. We think the court was correct in refusing to follow the Sardano case. We do not agree with its reasoning as to proximate cause, particularly its belief that voluntary antecedent would be an independent intervening cause. So the New York court just kind of disagreed completely on like everything. Isn't that how they tried and convicted the girl that encouraged the boyfriend to delete himself? Well, that was criminal and a slightly different argument. But you're correct that many people, including myself, were critical of the ability of the state to charge it for largely the same reasons. Like, yes, the girl who absolutely positively did everything possible to get her boyfriend to kill himself and succeeded in said goal. When charged with manslaughter, a lot of people, including myself, had questions for largely the same reasons. Now there are some distinctions that are there. You can make some fine distinctions to try to separate the two. But yeah, that happened, and yes, many people, including myself, were critical for largely the same reasons that we're talking about now. Although she really, really tried. She went way out of her way. So, you know, there's that. Yeah. Um, we find no other cases dealing with the question, but our own Supreme Court has held where A shot B, and as a result, B cut his own throat, from which wound he died. A can be found to be the cause of death of B. What the fuck? How does that work? They're about to explain it to me, but I'm trying to understand in my head before I read the next line. The Supreme Court of California found where A shot B, and then B cut his own throat, from which he died. A killed B. Okay. The court apparently said, but if the deceased did die from the effect of the knife wound alone, no doubt the defendant would be responsible. If it was made to appear, and the jury could have found from the evidence, the knife wound was caused by the wound inflicted by the defendant in the natural course of evidence. What? If the relation was causal, and the wounded condition of the deceased was not merely the occasion upon which another cause intervened, not produced by the first wound or related to it other than the causal way, the defendant's guilty of homicide. What the fuck? What the fuck? What? If the deceased did die from the effect of the knife wound alone, no doubt the defendant would be responsible. What? If it was made to appear, and the jury could have found from the evidence, the knife wound was caused by the wound inflicted by the defendant in a natural course of events. What scenario is this? What scenario is this where the knife wound was caused by him being shot? Was he shot in the throat? Was he trying to dig out the bullet? What are you talking about? If the relation was causal and the wounded condition of the deceased was not merely the occasion upon which another cause intervened, not produced by the first wound or related to it other than a causal way, the defendant's guilty of homicide. What the fuck are you guys talking about? What scenario is this where A shoots B and then B cuts his own throat, which is caused by A shooting B? What scenario is this? I don't know what the hell. What kind of scenario is this? I'm having trouble with this one, guy. Yeah, I'm having trouble with that one. I'm having trouble with that one. You can explain this? Oof. Yeah, what scenario is it where A shoots B and then B cuts his own throat, which was caused by being shot? What scenario is this? If the defendant would only be liable if they intentionally caused severe physical or mental distress, and the physical or mental distress was severe enough to be in the judgment of the trier of fact a substantial factor. Yeah. We find cases in which courts have recognized even voluntary suicide may be, both in fact and law, caused by wrongful conduct. The cases in which special duty towards the suicide exists, well, special duty may be. But then, if you have a special duty, you're talking about breach of duty, in which case you're talking about like negligence. Read People versus Lewis. Do I really have to read People v. Lewis? Figure out what the hell this is. I'm half tempted because it's like, yeah, they would have to have the knife in hand and fall on it. Yeah, that's like the only scenario that makes sense. That he has the knife in hand and he literally falls on his knife as he's falling down. Although I wouldn't really say that's B cutting his own throat in such a situation. I don't think that's how I'd characterize it. But yeah. Yeah, I don't. The restatement towards talks about liability for negligence. We skip that. And yeah. So I have many questions about this. I have many questions about this legal solidity of this decision. I have questions. It didn't sell me. And now we have to go look up People v. Lewis and figure out what the fuck the Supreme Court of California was talking about. What the God's name were you talking about, man? This better be good. Can I? 1899? I can't even find a copy of it. What the? It's not on Google Scholar. What the hell is this? All right, here it is. Shut up. Here's from Case Text. This better be really fucking good. I swear to God. All right. We turn our attention now to the case of People versus Lewis, Supreme Court of California, 1899. Holy shit. Uh-huh. Defendant and deceased were brothers-in-law and not altogether friendly, although they were speaking in visiting terms. On the morning of the homicide, the deceased visited the residence of the defendant, was received in a friendly manner, but after a while an altercation arose, as a result of which defendant shot decedent. Defendant shot the deceased in the abdomen, inflicting a wound that was necessarily mortal. Farrell fell to the ground, stunned for an instant, but soon got up and went into his house, saying, "Shoot me again, I shall die anyway." His strength soon failed him and he was put to bed. Soon afterwards, this is already great. Soon afterwards, about how long it does not appear, but within a few minutes, when no other person was present except for a lad about 9 years of age, nephew of the deceased and son of the defendant, the deceased procured a knife and cut his throat, inflicting a ghastly wound from which evidence of which, according to medical evidence, he must have necessarily died in 5 minutes. Okay. The wound inflicted by the defendant severed the mesenteric artery, and medical witnesses testified under the circumstances it was necessarily mortal, and death would have ensued with 1 hour from the effects of the wound alone. Indeed, the evidence was usually that the effect of such wound be cause of death in less time than that, but possibly the omnitum may have filled the wound and thus, by preventing the flow of blood from the body, had stayed its certainty for a short period. Internal hemorrhage was still occurring, and with other effects of the gunshot wound, produced intense pain. The medical witnesses thought death was accelerated by the knife wound, some of them considering it the immediate cause of death. Oh, okay. Now it's contended that in this case, where one is languishing from a mortal wound, is killed by an intervening cause, and therefore deceased was not killed by Lewis. To constitute manslaughter, defendant must have killed someone. And if, though mortally wounded by a defendant, Farrell actually died from an independent intervening cause, Lewis at the most could only be guilty of felonious attempt. He was as effectively prevented from killing as he would have been if some obstacle had turned aside the bullet from its course and left Farrell unwounded. And then they contend the intervening act was the cause of death if it shortened the period of life for any period whatsoever, which sounds right. The Attorney General does not controvert the general proposition, but argues that the wound inflicted by a defendant was direct cause of the throat cutting. And therefore, defendant is criminally responsible for death. He illustrates the position by supposing a case of one dangerously wounded and one whose wounds have been bandaged by a surgeon. He says, suppose through fever and pain, consequently upon the wound, the patient becomes frenzied, and terror weighs the bandage, and thus accelerates his own death. Would the defendant not be responsible for homicide? Ultimately, he would be, for the case is posed by the deceased died from the wounds, aggravated is true by relentless decease, but the wounds still inflict. But he didn't die from the bullet wound, so it doesn't work. The Attorney General seems to admit the fact, which I do not concede, the gunshot wound was not when he died, thus then itself directly contributory to the death. I think the jury warranted in finding it was. But if the deceased did die from the effect of the knife wound alone, no doubt the defendant would be responsible. It was made to appear, and the jury could have found from the evidence the knife wound was caused by the wound inflicted by the defendant in a natural course of events. What the fuck? If the relation was causal and the wounded condition of the decedent was not merely the occasion upon which another cause intervened, not produced by the first wound or related to it, the defendant is guilty of homicide. But the wounded condition only afforded an opportunity for another unconnected to a person killed, they'd not be guilty of a homicide, even though he inflicted a mortal wound. I don't understand this. My brain hurts. I don't understand this and my brain hurts. The case considered on this view is further complicated by the fact it's impossible to determine whether the deceased was induced to cut the throat through pain. Might have not been for remorse or desire to shield his brother-in-law. In either case, the causal relationship between the knife wound and gunshot wound would seem to be the same. In either case, the defendant had not shot the deceased, the knife wound would not have been inflicted. Suppose one assaults and wounds another, intending to take life, but the wound, though painful, is not dangerous, and the wounded man knows it's not moral, and yet takes his own life to escape the pain. Would be suicide only, yet the wound inflicted by assailant would have the same relation to death which the original wound in this case has the knife wound. The wound induced the suicide, but the wound was not, in the usual course, the cause of suicide. Though no case altogether like this has been found yet, as was to be expected, general subject has been considered. The law has been summarized thus: if one who gives another a dangerous wound, which might be very skillfully be cured, has not, is the cause of homicide. One inflicts a dangerous wound, the man dies from the treatment. If it can clearly appear that medicine and not the wound was the cause of death, it seems it's not homicide, but then must clearly and certainly be so. Well, that's true, but in that situation, again, it's like more direct, right? So that's true. Like if a person is wounded and as a result from the surgery dies, then the person who wounded them is still responsible. That's true. Even if the surgeon is incompetent, and it would have, even if they would have been fixed by a normally competent surgeon. So even assuming that the doctor was committing malpractice, it's still responsible. Yeah, that's right. And likewise, if it could be cured by relatively simple surgery, but the person for whatever reason decides not to have the surgery and they die, then they're responsible for that too. Or they choose to undergo a dangerous procedure that's ill-advised and not recommended and they die, then they're responsible. That's all true, but I don't think this example works. I'm not really sure how you can say that one is caused by the other. But that's what California wrote in 1899. So what can you say? As my mouse decides not to work all of a sudden. Mouse work. Mouse work. Okay, thank you. All right, we're done. What else can we talk about? I'm tired. I'm tired. How do we get this deep? How do we wind up in an 1899 case when we were talking about Maya? How do we wind up in an 1899 case about one brother-in-law shooting another brother-in-law in California when we got to talk about Maya? How did we wind up in that place? Yeah. An 1899 case with a brother-in-law shooting another brother-in-law somehow makes it into the Maya discussion. The law be like that sometimes. The law be like that sometimes. It always makes me smile, man. It always makes me smile. And that's also incidentally, once again, why the lawyers panic. Right? This is once again why the conservative lawyers panic every time someone wants to do something just this once, just this one time. Right? Just this one time, it's really, really important. This is why the lawyers panic, man. This is why the lawyer in me is a little bit concerned. All right. This is exactly why the lawyer in me is a little bit concerned about Johns Hopkins being liable for this death. You know, because what happens next? What happens next? Like, just this one time, let's lay down this brick. And all the conservative lawyers are like, no, don't do it. Don't do it. It's just this one time. It's really important. No. Right? This is where the conservative lawyers, do the whole like, no, that kind of thing in slow-mo because of this shit, because 125 years later, someone's going to be citing this for some god-awful proposition. God only knows what happens next, right? Yeah. So that's why the lawyer in me is concerned. It's concerned about Johns Hopkins' liability in this situation. Mm. I didn't think the Tate case was particularly great. I didn't think the Tate case was the end all be all, but apparently, at least the way the Florida case, at least the way Florida reads it, apparently it has become somehow the the basis for the development of common law on this issue. Okay. Yeah. There's no way this doesn't wind up at the Florida Supreme Court someday, unless they settle. There's no way this doesn't wind up at the Florida Supreme Court someday. Did I see a juror got 150 days in jail for causing mistrial? I sure did. I think 179 to be precise. They earned it. They deserved it. I got a new watch. I got a new watch at my local pawn shop. I've been wearing. It's now my new. It's no. It's not. It's at least for the moment. It's my EDC watch. So it's my everyday watch now for a while. I got this nice G-Shock Solar Atomic model 5100 for $40 at my pawn shop. Retail price $120. It's solar. It's solar and atomic, so it automatically sets itself using the radio from Colorado. So it automatically sets itself every day, and it's got like the little bars on it. It's got the little bars on it to help keep the face from getting damaged. That's nice. And it's a G-Shock, so they are bulletproof. So $40. I'm very excited about that. Yeah, I'm very excited about that. I'm not so sure about the strap. I may replace it, but why not? I'm using that for a while. They also had a Breitling. The pawn shop had a Breitling for $3,000, but no papers. I thought about it for a minute, and then I decided I can't do it. Right? They had the box. They had the box, but they didn't have the papers. And first of all, $3,000 is a lot of money for me at this point in my life. So I don't necessarily have $3,000 to just spend because I'm not Destiny that has millions and millions of dollars. And second of all, buying a fancy watch without papers, man. The pawn shop said that their shop was broken into and the papers were stolen, which I believe them, but still no papers, right? Yeah. I don't really have $3,000 to float around. I'm living a very sort of middle class lifestyle. I actually don't know how much money I made. I guess I'm gonna find out pretty soon because I have to pay my taxes. Yeah, $3,000 saved for a ring. Yeah, yeah, yeah. No papers means it was fenced. It could mean that too. Yeah. The quality of fakes these days are so good. The quality of fakes these days is so good that it's like that's okay. But the pawn shop sold me the $40 G-Shock and it's working great. Doing the business taxes is always pain in the ass. It's not actually that bad because since I'm a sole proprietor, LLC, it all is pass through income. So it just winds up on my personal taxes essentially. And then I just have to do the schedule whatever for all the deductions, which isn't that bad. It's not that bad. I'm still gonna have someone else do it, but it's not that bad, right? Because it's just personal income. So, do I have an accountant? Yes, I do, as a matter of fact. I do have an accountant. Am I streaming tomorrow? Yes, I'm probably going to be streaming my discussion with Destiny tomorrow at some point. That'll be fun. I don't know what a Massimo M1 is. And I like my G-Shock. I've always liked watches that just do watch stuff. So if your watch does things other than watch stuff, I had a Pebble when it was brand new, when Pebble was like a brand new company and a Kickstarter. I had a Pebble. I really liked the Pebble. I was sorry they went out of business, but Pebble was a smartwatch that was pretty cool. I was always sad they went out of business because they made a cool watch. But all my watches other than the Pebble have just been watches, right? I have plenty of mechanicals. You know what they do? They tell time, right? So I don't really need a watch that does anything other than tell time. Plus, this one is great because since it's solar, it never has to be. I never has to change the battery, right? So you never have to change the battery. So, thoughts on the Murdoch thing? Yeah, we talk about it. I think the defense has. We're going to have a hearing, and we'll see what happens next. Destiny has millions and millions and millions of dollars. I'm slightly envious and slightly resentful. You know, Destiny is a streamer who is a multi-millionaire. He has his own personal chef who is behind him on stream that makes guac in his house. So I'm a little resentful. He has like 10,000 people watching his streams, even when he's not really doing anything. So I'm not sure what it is, but you know, I'm over here like, you know, making somewhere between like $50,000 and $100,000. I'll see exactly where I am when I do my taxes. And he's over here with the millions and millions and millions of dollars. So I don't know, man. I don't know. Money is not everything. That's true. Money is not everything. That's true. And in the grand scheme of the world, I'm still pretty lucky. I'm still one of the luckiest people on the face of the earth. I'm trying to remember what the average income in the world is off the top of my head. And I forget. I guess I could Google it. Hold on. Let's look it up. It's been a while. What is the average income in the world? About $9,700 US. I didn't think it was quite that low, but yeah. So even if I'm making like $50,000, first of all, I'm making more than the average man, and I'm making more than the average global income by quite a lot. So if you make over $100,000, it puts you in the top 10% of earners in the world. So it's always helpful to keep things in perspective. Yeah. And to be in the top like 1% of Americans, you only need to make about 400,000 a year. It's less than people expect. The top 1% in Americans about 400,000. Might be a little bit more now, but not by much. So it's not as much as you might think. I mean, $400,000 a year is not chump change by any stretch, but You know, if you ask the average person on the street how much money do you need to be in the top 1%, I think they come up with a much bigger number. Yeah. Yeah, if you make over 100K and you can't afford an apartment in San Francisco, yeah, no doubt, right? One of the reasons, like, I always try to cut my cost of living, right? I cut my cost of living by moving to Austin. And then I cut my cost of living by moving different parts of Austin. So I saved about $300 a month when I first moved to Austin. And then relative to what my rent was going to move to, I saved something like $700 a month. My rent was going up so much. So yeah, and now I'm going to be saving an additional $200 a month when I move to Houston. And I'm getting more for it. I'm getting a nicer space, bigger space, and I'm paying less. So, you know, just try to cut your cost of living down. I lead a reasonably happy life. You guys keep me fed. You guys keep me fed. But I don't have, like, you know, just money to, like, throw around. So I have to be careful about how I spend money. So but my quality of life hasn't really diminished very much, which is ironic. It's like when I was making like 3 times as much as I'm making now. And at least subjectively I didn't feel like my quality of life was any better. So I'm like, what the hell was I spending all that money on? You know, that's sort of the thing going through my life. I was making 3 times as much as I am now. What was all that money going? Where was all the money going? You know? I don't have a good answer to that question. I think it was going a lot to eating out. I used to spend a lot of money going out and eating food at very nice restaurants. That's probably where a lot of it went, was to fine dining. Yeah. But on the plus side, I did save for my retirement. So I've got, you know, money set away in my 401k. So hopefully I won't retire broke. So, you know, we're doing okay. Am I not taking cases anymore? I'm doing very, very little on the side. I'm doing very little on the side. But no, not really. Yeah. I need to go into a new field of law. I need to do something completely different. So I basically need to start over. I need to find someone who will hire me as an entry level associate in a completely new field of law, which for a person who's been out of law school for like 17 years is not an easy proposition. So I'm not sure why it shouldn't be an easy proposition, but it's hard. Right? They'll hire a guy right out of law school to do it, but they won't hire me. I'm not sure why, but they won't. Yeah. Anyways, I'm going to sign off for now. Yeah, the depression was the big thing that was getting to me, right? And the depression was just caused by the job itself. But that's, you know, because I just couldn't do it anymore. I just couldn't do it anymore. When I was cooking for myself when I was doing a day job, no, I was always eating out like crazy, and I was eating out at very expensive places. I ate well. I had good food, but I guess it ate up a lot of expense. It also didn't help that like drinks in DC are so expensive, so your alcohol budget goes up a lot because you go out for a drink, it's like $15. You know, drinks in DC are expensive. So, anyways, well, I'll sign up for now. I've been Uncivil Law. To later, my friends, I hope all is well. Cheers, my friends, and goodbye.